So thank you for the invitation. It's a pleasure for me to be here, and I hope that I can be useful for the topic of this beautiful project. I'm international tax law research, so I will try international tax law professor in Rome. I'm visiting researcher here in Vienna, and I'm trying to give my contribution. I will talk about the plea agreement and tax crimes in Italy, in our system. So, from a legislative point of view, we have to see that in Italy, tax crime are set out in a specific legislative decree, the number 74 of 2000, and the criminal code and criminal procedural code apply to criminal proceedings in tax cases. Under the Italian criminal law, the plea agreement that we call patteggiamento, governed by the Article 444 of the Criminal Procedure Code, allow the defendant to avoid the trial, but only in relation to crimes punished by the less than 5 years imprisonment. Under the plea agreement procedure, the defendant legal counsel and the public prosecutor agree on a punishment before the beginning of the trial. Plea agreement allows a reduction of up to 1/3 of the criminal punishment provided by the law and must be requested to the judge in the preliminary hearing. The judge verified the classification on the offenses, and if the agreement include an appropriate penalty. And if the judge accept the plea agreement request and apply to a penalty of imprisonment no higher than 2 years, the crime is extinguished if the defendant does not commit a crime of the same nature within 5 years following the judge's decision. But what happened in a tax environment? So for tax crimes, plea agreement can take place only if the amount payable are paid before the beginning of the trial. This is at least what the Article 13bis, paragraph 2 of the legislative decree number 74 of 2000 says. So something clear, we can say, at least apparently, because this provision seems to preclude for all tax crimes access to the plea agreement for taxpayers who have not previously paid the amount due to the tax authority. So as I said, something clear, but generate in our system several problems from a constitutional point of view and also from an interpretative point of view. So the provision in question appear immediately contrary to to some constitutional principles, and therefore it was the subject of several orders of preliminary referral by various courts. Also, the doctrine found the violation of the Article 3 that states the right of equality and the Article 24 of the Constitution. According to them, the law created disparity between subjects accused of the same crime but with different economic conditions. The law, in other words, limited the right of the defense of the accused with the delicate economic situation. So, in short, who can pay can have access to the plea agreement, and who can't, unfortunately, doesn't have any access to this particular regime. So this is what the doctrine and the court were used to say. However, the Constitutional Court has sanctioned the full legitimacy of the Article 13bis, paragraph 2. According to the constitutional judge, the provision, however, would neither violate the Article 3 of the Constitution nor the right of the defense pursuant to the Article 24 of the Constitution, since the denial of the right in relation to a specific category of offenses does not undermine that incompressible core of the aforementioned right. So, from a constitutional point of view, we can say that we solved this problem. But what happened from an interpretive point of view? So, the access of the alternative right of the plea agreement in terms of tax crime has given rise to numerous interpretative issues. But why? So, let's read together the Article 13bis, paragraph 2, who provide that For the crimes referred to this degree, the application of the penalty purpose to the Article 444 of the Criminal Code may be requested by the parties only when the circumstance referred in the paragraph 1 occur, as well as the voluntary disclosure, without prejudice for the hypothesis referred to the Article 13, paragraph 1 and 2. So there is a strong connection between the Article 13b's and the previous article, the 13. So let's read also the 13th article to understand together what happened. So the Article 13 of the legislative decree number 74 of the 2000, as amended by the legislative decree number 158 of the 2015, is entitled Grant for Exemption for Penalty, Payment of Debit, and read as follows. No penalties shall be imposed for the offenses set out in Article 10 bis, 10 third, and quarter, paragraph 1, if before the proceeding at the first instance are declared open, the tax debit, including administrative penalty and interest, have been extinguished by the payment in full of sum owed, including where such payment result from special circumstance, procedure, and procedure for agreement or the assessment whether laid down by the tax rule or for voluntary payment. So the Article 1, Paragraph 1 provide for a hypothesis of cause of no punishment in a strict sense. I mean, if the agent is guilty of one of the crime or failed to pay, but nevertheless provide for the full payment of the tax debit within the declaration of opening of the hearing, the Italian legislator, renounced to punish him. So this is a provision that constitutes an incentive for the correct fulfillment of the tax obligation and at the same time has a deflattering function of criminal proceeding. So even the crime of fraudulent reporting enjoys similar cause of no punishment. Indeed, in the Article 13, paragraph 2, not paragraph 1, but now we try to analyze the paragraph 2, the second paragraph, modified by the law number 157 of the 2019, provide the possibility to extinguishing the crime of fraudulent reporting through the full payment of tax debit with voluntary disclosure. This will be possible only before the offender has had formal knowledge of access, inspection, and audit, or the beginning of any activity of administrative assessment or any criminal proceeding. So the presence of the two articles, the 13 and 13b's, has generated numerous interpretive issues. If initially the Supreme Court of Cassation interpreted the aforementioned provision as an obstacle to access to the appeal agreement for all tax crime, later the court developed a different orientation, which have gradually consolidated, affirming that the absence of the payment of tax debit in the case of the crime of value of pay is not an obstacle to the access to the special right governed by the Article 445. But why? Because according to the Supreme Court, since the payment of the tax debit to be made within the opening declaration of the trial represents the cause of no punishment of the crimes pursuant to the Article 10 bis, 10 third, third quarter, the same cannot logically and at the same time and for the same hypothesis also act as a prerequisite for the legitimacy of the application of the penalty, which physically certainly could not concern no punishment offenses. I mean, if I pay, I will not be punished. So if I can benefit from this no punishment clause, so there is no reason to have an access to the plea agreement. This is in short what the court is saying. The solution accepted by the judge of the court has an appropriate and logical, also in my opinion, and systematic base. For the crime of failed to pay, in fact, the condition for accessing the cause of no punishment seems the same as those necessary to access to the special right of the plea agreement. And the same section of the court later decided also to extend the principle referred to the declaratory offenses. So, in conclusion, what can we say? As we have seen, there is no unambiguous view on a relationship between the access to the right of plea agreement for tax crime and the necessary or not of the preventive extinction of the tax debit within the opening declaration of the hearing pursuant to the Article 13b's, of course, paragraph 2. In any case, it is known that since the 2018, the prevailing orientation, both in relation to crime of failed to pay and lastly to declaratory crimes, seems it is unnecessary to pay the debit in order to benefit from the special right of plea agreement. Based on a logical and systematic consideration, and honestly, I totally agree the orientation of the Supreme Court, because the Supreme Court considered that the requirement for accessing to the cause of no punishment pursuant to the Article 13 cannot in the same way constitute an unavoidable prerequisite for being able to negotiate, or it would not be possible to apply a penalty to a no punishment offenses. So it followed that the offender not paying tax debit can always request the application of the penalty pursuant to the Article 444 of the Italian Criminal Code procedure. So I hope that it was interesting to see how a clear rule in Italy generates some issues from a constitutional and interpretative point of view. In Italy, we are used to see this kind of approach. There is a Latin expression, in claris not fit interpretatio, and probably this is the proof that is true. So even if the Article 13 bis was pretty clear, the Constitutional Court elaborated thesis, and honestly, I totally agree, as I said, and this is the Italian situation. I mean, we can benefit to the plea agreement in tax crime, even if we don't previously pay the tax debit. And this is right, in my opinion. It could be nice also to see your point of view. But that's it. Dankeschön. Thank you for the attention. Köszönöm. And I finished my languages. So that's it.